Morning.
Good morning.
Good morning.
Good morning.
Okay. Good morning to all of you. We are here for um, the, uh, I believe it's a final hearing on the petition for review that was filed by Ms. Marzarati regarding a judgment that was entered um, by the um, lower court, by the magistrate court, on the dispossessory action. So, as I understand it, the final judgment and what was appealed by Ms. Marzarati was the right to possession. There was a money judgment that was entered to the landlord, some of which has functionally perhaps been satisfied because I think most of it was for back rent, which Ms. Marzarati had to pay into the registry in order to maintain possession for for the course of this case. And then there was also a money judgment that was granted to the tenant in the lower court. Because it is Ms. Marzarati's burden, because she's the movant here, I'm going to start with her. Let me ask you this, Ms. Marzarati. Um, Given that this was a dispossessory action and that you have paid into the registry, based on the prior judgment, my understanding is there's not a dispute that you were a tenant and that you had a monthly obligation to pay rent to maintain possession of the property. Is that correct, Ms. Marzarati?
That's correct.
Okay. Um, and at some point, which is what resulted in the dispossession, you stopped paying rent. And I understand that why you stopped paying rent is part of the reason for this litigation. And I'm going to hear from Mr. Neal and Ms. Terry regarding their position on that issue. And that ultimately, the fact that you hadn't paid rent is what resulted in the dispossession action. The dispossessory judgment that I saw was a judgment granting possession to Mr. Neal and Ms. Terry, subject to obviously appellate rights, which you have exercised, and entering a money judgment to the landlord and also entering a money judgment to the tenant. That's the judgment that I understand we are here about, and all three of those items were identified in your petition for review. And so, Ms. Marzarati, if we can start with you in terms of why you believe and what evidence you're going to present regarding your right to possession of the property and the basis for any judgment that was entered in your favor, or why you think there shouldn't have been a judgment entered in the defendant's favor, because that's sort of what we're here on. Go
Okay.
ahead, Ms. Marzarati.
So as for possession, our last judge didn't take into consideration that we've already paid our last month's rent. So as of today, we have paid this month's rent and our last month's rent. So I would like to stay in the house until the end of May, would be because we've paid this month's rent and last month's rent, and terminate our lease at the end of May. Otherwise, be refunded the $3,500 for our last month's rent, because we've already paid that up front. And
Okay. Well, let me ask you this before you go further. I understand that y'all don't have lawyers and there's a lot of negative feelings between the parties. Have you had a chance to communicate that offer, not here just now, but previously to Mr. Neal and Ms. Terry regarding your offer to voluntarily vacate the property at the end of May?
No, ma'am. We haven't had
Okay.
communication since November 4th,
Okay.
other than through the courts.
Okay.
I would also like to say that on our last hearing, they had said that I had used my health to prolong this proceeding. And I went back and looked, and it wasn't when they first filed Actually, this is irrelevant for right now. Sorry.
I was
But
going to tell you that in a moment, but thank you for realizing that.
sorry.
And mainly the reason I think it is irrelevant is that I understand that's probably a concern for the Neals, for Mr. Neal and Ms. Terry, but ultimately we are here now, and that's what matters. The court is prepared to hear the case and to rule. And so, what
So
got
the
us
whole
here?
case started because in July, I called the housing authority as things were not being fixed in the house.
Mhm.
And then I was told that I was going to have to vacate the house, and we were still paying rent and everything. So in October, I paid the rent, and then I was given, which the court has a copy of, a document that was like a ledger, but everything was like redacted from it. So you could only see that it was for landscaping and for painting the house. You couldn't see what it was for. And so I asked for clarity as to what I was paying because I had already paid the $500 late fee and the $3,500 in rent. And Miss Terry, refused to give me any more. She was basically, if you go back and look at the text messages that I sent you, she was like, that's not really any of your business. You just have to pay it or I'm evicting you. And I didn't think that was fair. And so that's what brought us to this place, was that I wanted more clarity as to what I was paying for, because I don't think I should have to pay to paint their house and stuff that isn't in the lease that she keeps requiring me to pay. And when Miss Terry is upset, she tends to basically be like, you do this or I'm evicting you. You do this or I'm evicting you, which is why when Mr. Neal filed his thing saying that I voluntarily paid these late fees, it wasn't that I voluntarily paid. When I asked her about it says in our lease on the first page, it's $100 late fee. When I asked her about that, she was like, no, it goes up in increments. Every time you're late, it goes up. So I paid 100, I paid 200, and I get paid on the first Friday of the month. And it's a paper check because I have cancer. I work as a consultant. And so I have to deposit the check and then pay the rent and everything. So 90% of the time it is late because I get paid on that first Friday, which could be a fifth or whenever. And so I just have to suck it up and pay those fees. But to have to pay those fees and then not have things be fixed and have to pay to paint or be told that I need to pay to paint their house or to other things, it got to a point where it was too much and it was unfair to me. So if you'd like to go down what I was asking for, is that where we're at?
It is. I would like a little bit of context for
Okay.
something that you said a moment ago. So tell me when you moved into this property.
I believe it was, I'm looking at the lease. Uh, May 1st of 2023. No,
And
no, I apologize. It's 4/14/2023 is when it starts.
okay. And you had an opportunity to inspect the property before you moved in.
I did. And then I sent her a list of everything that needed to be fixed, which you have a copy of.
Mm-hmm.
It looks like this.
Okay.
And on it was the fridge. I'm going to read to you. The master toilet seat, the master shower handle, the master remote is missing for the fan, Maya's bedroom closet light, the guest room toilet seat is broken, the laundry room, the washer is broken, the dishwasher leaks on the ground, but it works. And the dishwasher is still leaking.
Okay.
The fridge, the water,
Ms. Mars, hang on. So I
sorry.
have that document. I can review
Okay.
it right now. What I'm
Okay.
trying to do is be efficient in terms of asking you questions about what's been presented to me. So then I can,
Okay. So
um,
they did have a list of everything that was broken.
so
And
here's my question. So you had an opportunity to inspect the property before you moved in, and you
no, it
made a
was
list
after I
of
moved in. So the inspection was done on May 2nd.
Ms. Marzarete. This will be helpful if you will let me ask my whole
Sorry,
question, even if you know what it is, and then answer.
my
Okay.
apologies.
So your lease started on April the 14th. My
Hmm.
question to you is, were you given an opportunity to inspect the property before you signed the lease?
No,
Okay. So you signed a lease and agreed to be legally contractually bound to a property without ever inspecting it?
no, my daughter and I went and saw it beforehand.
Okay.
I thought,
Okay.
but we
So
didn't
you
like
did have a
flush the
chance to review.
toilets.
So you did have a chance to see the property and inspect the property before you signed the lease.
We saw the property, but I wouldn't say we inspected it because I didn't know that the
Well, I didn't
stovetop that
ask
three
if you
burners were.
inspected it. I
Okay,
asked if you had an opportunity to inspect
sorry.
it. And it sounds to me as if you did.
Okay.
And then at some point from that text message, at some point shortly after you move in, you provide this list of things that you believe are not sufficient for you to be able to live in the property, correct?
Correct.
Okay. And how long did you live there before you contacted the housing authority?
So the housing authority was contacted in July of 2025.
Okay. And just to sort of help me understand like some context, what what um what changed? What happened that brought this to a point where you were contacting the housing authority, to your
So
understanding?
to my understanding, beforehand, Miss Terry was great at fixing things. Like our air conditioning broke and she fixed it. But anytime I asked her to fix the fridge, she was like, no. And then my daughter's bathroom, the shower stopped working, like the water just stopped coming out of it. And then on top of that, the stovetop was still down to one burner. So, and I sent you all a video this morning. It's still on the one burner. And so I couldn't get her to fix anything, and we're paying full rent for all this stuff, and things aren't working. Like my daughter's having to shower in my bathroom
Mhm.
and use my sink. And so I'm like, this is crazy. Well, really, it was my daughter's grandfather that was like, this is crazy that we're paying this amount in rent and late fees, and you guys can't fully appreciate and use your own house. But when I had text Miss Terry, which you have these, about like the air conditioning broke, she at first was like, just go downstairs, the one downstairs works. And so I was like, well, then do I only pay you half the rent because we're only able to use half the house? And she was like, no, you pay your full rent. And I was like, you have to understand, I have cancer. That our stovetop doesn't work, our fridge doesn't work. Now we don't have air conditioning. And she responded back, cry me a river. And so even when I did call the housing authority, Miss Terry called the police on myself and Officer Hightower and stated that we had violated her constitutional rights by letting the government into her home and tried to have us arrested. So when there is a real threat by not paying that, like she's going to take some type of action, which is why I would go ahead and pay the $500 late fee rather than fighting with them.
And the late fee that you're talking about is a late fee that you were paying your rent late, and the a lease agreement that you have with Mr. Neal and Miss Terry carries with it late fees that accrue if you pay your rent late. And so you were
It's
paying those
so
late fees. Is that what you're referring to?
on the first page of our lease, it says $100 late fee. And
Right. I understand that you want to. So I understand there's a discrepancy about the amount. That wasn't
okay,
my question. My
sorry.
question is, you understand that the lease has a provision that says if you don't pay your rent by X date, there's a late fee, right?
Oh yeah, absolutely.
Okay. And so what was happening when you say, so I went ahead and paid the late fee, right? What I'm trying to make sure I understand is, so there's a dispute about the amount,
Mm-hmm.
right? But you're saying that you paid the late fee because Ms. Terry otherwise, that's the part I'm not understanding.
They're saying I voluntarily paid the late fee and agreed
Uh-huh.
to that amount. I didn't agree to that amount. I paid
Okay.
it because I didn't want the police called on me. I didn't want to be
Okay.
evicted. I
Is
didn't want
there,
to be threatened.
so or is there, I mean, not that, is there any, is there any documentation, any communication you want to direct me to? Because you've both of you have provided me with a good deal of communication between the
Yes.
parties, that would indicate that you were, attempting to reserve your right to challenge that late fee, that you were paying it under duress or anything like that. That
Yes.
in any of those communications you want to point me to.
There's text messages that I ask her. I say, the lease says it's $100 in the late fee, and she says it's $100 and it goes up per increment, which means each time you're late, it goes up $100. And so I say, I don't think that's correct. And she says, well, you can pay it or get evicted.
Okay. Please continue. I'm letting you present, and then I'm asking questions as you go. So please
Okay,
continue, Ms. Maserati.
um, so I continue to pay, and do you have any more questions about the late fee, or are we moving on to something else? I'm sorry.
Was the late fee, as you understand it, was the late fee any portion of the damages that were awarded to you by the
Yes.
lower court?
It was, he gave me $9,600, which was what I asked for at the time. I asked for the 24 months at $500 a month. If you subtract, it would be the difference is $9,600. Then when I appealed, I realized that I had also paid like the $200, then the $300, then the $400. So
Mhm.
I added that $700 difference, which made it $10,300, which I hadn't asked the previous judge for. It was the other $700.
Okay, but a portion of the underlying judgment that was awarded to you in the magistrate court did include that $9,600
Yes,
for
ma'am.
late fees. Okay, thank
Uh-huh.
you. Go ahead.
So yeah, so I just added the $700, which was the $200 late fee I paid, the $300 late fee, and the $400 late fee I paid.
Mm-hmm.
Which brought it to a total of 10,300 instead of 9,600.
Okay, Ms. Marzarati, can you tell me, I think I understand you to be saying that the things that you were complaining about the property still have not been repaired. Is that accurate?
So the stovetop is still not repaired, and that's one of the reasons that so Officer Hightower needed to come back and re-inspect the house. After she called the police on both of us, he was a little terrified too and wanted to make sure that Miss Terry was there also present when he comes back to the house to inspect. I sent you a text message from him this morning. I reached out to him. He's on leave. And he said, sorry, I'm looking for this. I don't want to put him wrong. I didn't ghost Miss Terry because that's what she told you on our last video. I tried to do my reinspection, wasn't granted access to the house, to the property. So the reason the access was not granted is because the stovetop still was not fixed and they would be charged $1,000 a day until they fixed it. So she
Ms.
kept postponing
Marzarati,
the
I apologize.
reinspection.
I'm not understanding what you're saying.
So
Hang
officer,
on.
sorry,
My understanding is that you are in physical possession of that house.
Yes, ma'am.
And you're telling me that the inspector from the housing authority showed up and says he wasn't granted access to the house, even though you're the person who controls access to the house.
So that's why we were not arrested, ma'am. Was because when she called the police on both Officer Hightower and myself to say that we violated her constitutional rights by letting the government into her house, we were not arrested because the police were like, it's her property. She's the one renting it. She can let in whoever she wants to the house.
Okay, I understand that occurred. That's not my question. My question is, the second time I thought I understood you to be saying that I didn't come and inspect the house because because I wasn't granted access to the property. And again, I don't understand
So Miss
why you were
Terry
not
said that
able to
she had
open
to.
the door and allow that inspector into the house to inspect it.
So Miss Terry said that she wanted to be there, that I wasn't allowed to let the government back into her house. And
Okay.
so then she would not follow up with Officer Hightower to do the reinspection. So that's why he said Miss Terry would not grant him the opportunity to come to the house. You have to remember, she called the police on both of us saying we violated her constitutional rights. Neither one of us wanted the police called on us, so we were adhering to what she was saying. And so she was supposed to come and do the reinspection with him. And she never allowed him to because the oven is still, or the stovetop is still not working. And so she didn't want to be fined that $1,000 a day.
Okay.
That's why, and you have the text message from Officer Hightower that says that she would not grant him the reinspection.
Okay. Which is hearsay. And it is not really properly in front of me. That's one of the reasons I was asking your understanding of the posture
I
of,
can call him and have him be a witness if you'd like.
so that if he's available, then he might need to be a witness. But right now, I'm just letting you know that his text messages are hearsay, and he's not here to lay a proper foundation for why they would
I
be
just wanted to
admissible.
clarify because Miss Terry said that he ghosted her on our last Zoom. She
No,
said he ghosted
I
her.
understood why you were presenting it to me. I'm just pointing
Okay.
out to you that his statements are out of court statements, and therefore there has to be a legal foundation for why they would be admitted into evidence. And I'm just
Okay.
saying that currently I have not heard that legal foundation. Go ahead.
Um, I was just rectifying what she had stated that was incorrect about him ghosting her because that was not true at all. And
Okay.
so I can text him and ask if he could be a witness. I know he's
Let's
currently at a
just
doctor's appointment.
let's just keep moving forward with the
Okay.
issues we have and the parties we have in front of us. Go ahead.
So the broken fridge, are we good on the late fees, or do you want me to testify anything else about
No,
them?
I understand. I understand the issue regarding the late fees.
Okay, so should we move on to the fridge and the stovetop?
It's your case. You can present it in any way you wish.
So the stovetop, as I said, still is not working properly. I sent a video for all of you to see this morning where only one burner turns on and then the rest of them click, 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 click. And they just didn't, it was over 40 seconds and they still hadn't. So I showed you how I manually have to light it with a lighter, I guess. And so it's very dangerous. Like I can't let my daughter cook on the stove because when you light it with the lighter, it goes whoosh, and then the flame comes. And Miss Terry and Mr. O'Neill are very aware of this because in the text messages that you have copies of, Miss Terry calls me an idiot and tells me not to put my face in front because I was complaining that it's dangerous for my daughter to cook and that our hair could get burned and that her husband had acknowledged, like, be careful of your guys' hair because of the way this whooshes. Once the guy came to fix it for the third time. And so she's just like, don't be an idiot. Don't put your face in front of the stovetop and you'll be fine. Like, just, but the point is even before the last court date, I burned my finger and all of the hair was burnt off of it by manually doing it. When it whooshes, you have to like jump backwards or you can get burned. And so I just don't want my daughter cooking in an unsafe environment because she has a lot of hair. And so it's just not safe for her to use the stovetop like that. So I bought other appliances, like I bought an indoor grill so I could use that instead because only one burner is working. And I'd like to go back to, so from the beginning, when I notified her that the stovetop wasn't working, she did send someone out to fix it. He ended up, and he was supposed to fix the fridge too. He ended up saying that it couldn't be fixed, that she needed to buy a new one. She ended up calling the police on him because he had bought parts for the stove to be fixed, and then he was going to return the parts and then give her the money back. And he was taking too long or something, and it had been a week and they hadn't been refunded their money. So they went to the police and tried to have him arrested for theft too. And after that, there's text messages that I have provided for you that show I'm asking her, you know, when she told me she ordered a stovetop from Lowe's and that it was going to be delivered. She asks if it's been delivered. So she's acknowledging that there is an issue that needs to be fixed, but it never gets fixed. She just keeps delaying it and delaying it and delaying it. And then when I did call the housing authority, she sent over some guy and he you can see from the receipt he just like cleaned up the burners and stuff like that, but it's still not working. It needs a new stovetop. So in the 3 years that we've lived here, it has literally been one burner. And I've sent you all of the text messages and everything about the stovetop and the videos. So you have her acknowledging that she called Lowe's and she ordered a new one. And she literally asked me if they've delivered it. And I'm like, no, they haven't, you know. And she's like, oh, weird. I'll have to call them and look again. So she's known all along that that stovetop was not working.
And so I know there was also an issue with the refrigerator, if you wanted to address
Yes.
that.
The refrigerator, so, and I have given you copies of this. Sorry, I have like 200 files with all of our stuff. So the refrigerator, I asked her to, so this is what I want to show you. And this is all in your packet. So here. So when we looked on Zillow, this was the refrigerator that was there. And when we came to see the house, then when we moved in, she had traded it out for this refrigerator. And this is the current refrigerator that we now have. So she did fix the refrigerator. And so for 6 months, we had the black fridge and we had to use the freezer as the refrigerator because the refrigerator would not cool. And I was asking her to fix it and she would not. And so she keeps saying that I overstuffed it and all this stuff. But the day that they saw it, Your Honor, and I've included this. So on July 19th, I ordered from Amazon. And this delivery was delivered to my neighbors or somewhere. So they had to resend me on July 20th. And if you see, everything is like $0 because it was a replacement. Well, when this got delivered, the neighbor brought over this order too. So it looks like I have a ton of food, but really on the day that they came, 2 orders were delivered. And I explained that to them. And so we got 2 lots of groceries because the first one was missing and then the second one shows up the next day. So it looks like I'm purchasing like $400 worth of food, but realistically it really was 1 week of food that just ended up being twice because of a order going missing and delivered to the wrong house. But I have presented you with her, acknowledging from the beginning, like, I will ask Shane if he can come back and fix the fridge. The stove tech will be there, the refrigerator, like, she's acknowledged from the time we've moved in all the text messages that, this was not, and this was the damages that the other judge did grant me was for the fridge and stovetop, and the amenities not working was the other $1,900.
Okay.
Do you have any questions about the fridge or the stovetop for me?
Not so far, ma'am.
Okay. So going to my next point was that us not being able to use the amenities. My daughter right now is at Eagle Rock Camp, and so she is going to call into the call when I tell her it's her time because her internet is kind of hazy right now at Eagle
How old
Rock
is your
Camp.
daughter?
She's 18. She's a senior in high school, and so she just won a scholarship. She is dyslexic and dysgraphic, and she started a program in South Fulton for kids that are in elementary school that are also dyslexic and dysgraphic. So her and her friends go and talk to the elementary school kids and give them capes.
That all sounds very wonderful.
So
The
that's
only
why
reason
she
I
won.
ask, the reason I ask is that I'm not certain if the only reason for her to call in is to say that she tried to use the pool and was not able to do so. I feel like you can represent that to me.
Okay, and
But
also
if
her
there's some
bathroom.
other reason that you wanted to have your daughter testify about something that you're not able to testify about,
No, I can
I
testify.
certainly would hear from her if you wanted me to. I'm just letting you know, no reason to go through that trouble if what she's going to tell me is something that you're able to tell me as well.
Okay. And I also had my best friend Shelly was going to testify too about the fridge, but I don't think, if you don't think you need to hear her, because of the cancer, Shelly was the one that would come and help me clean and stuff like that. So she has full knowledge of the fridge not working and us having to use the freezer as the fridge, and then the freezer like being full of ice. And so she would have to defrost it and clean it all the time.
But you said there was there was originally a fridge, and then when you moved in, there was a different fridge.
Yes.
But I mean, a fridge is a fridge.
Yeah.
And then at some point, I thought I understood you to say that there is a new fridge there now. It
So
was
once I called the
replaced.
housing authority, Mr. Neal or Mrs. Neal and Mr. Terry, no, wait, I said that backwards. Mr. Neal and Mrs. Terry did, when the housing authority was called, they did replace the fridge.
Okay, so the refrigerator was replaced in sometime in July of
Yeah.
2025. Okay. And the part of the judgment that was related to the fridge was for not having an operable fridge for some period of time.
Yes, ma'am.
Okay. Okay. Go ahead, Ms. Marzorati.
So then next on my list is the not being able to use the amenities. And the HOA stuff. So the ledger that they provided to you, this is the first time that I'm actually seeing this. And this was great because I have, again, never seen that and not known what it was for, but it also shows you that they have been behind from the beginning. And that's what I was saying is we haven't been able to use the amenities because since we've lived here, they have been behind. So I also provided you with text messages from the old HOA president that says that she says, we can't use the clubhouse because your owner has been behind for 2 quarters. They have not paid. Priya, it would be worse if I hadn't waived the fines for the lawn, but unfortunately, she was a problem before you rented the house. So she acknowledges that she actually did waive a lot of the fines because they knew I had cancer. And she acknowledges that we haven't been able to access the pool because she's not current. And I asked Miss Kia, I was like, this is June of last year. Maya's asking when she can use the pool. And she was like, well, we're behind, they're behind in the HOA fees and there's violations. And so you can't use it. But they've been behind and the ledger shows from the beginning, before we even got here, they were behind on their fees and fines. And so this ledger shows that this has always been an issue. So
I understand that there might be some things on that ledger that indicate that perhaps the owners of the property maybe were not timely paying the assessments or something like that. But there are also a number of violations that the Terrys have provided to me where they're being provided notices from the HOA for violations for which they're being fined that their position is that's in the lease that you're required to do. Like, for example, not mowing the lawn or leaving garbage on the street, things like that.
So that's what I'm saying. The HOA president she took away my fines knowing that I had cancer and she would waive them. And
Forgive me for interrupting you, Ms.
No problem.
Marzorati. I have a call coming in that I need to take, so I'm going to take a quick break. I apologize. Just a couple of minutes, and I'll be right back with you.
Okay. Thank you.
I am back. If everyone else is ready, if you needed to take a further break, I was a lot faster than I thought I would be.
No, you're good. My daughter won the scholarship.
That's wonderful.
Thank you. Um,
Okay.
I'm
So
so
I
sorry.
think
I
where
have a
where we
memory issue because of the chemo, and I can't remember where we left off.
I was just going to say where we left off is that we were talking about HOA assessments, and I had asked about, what about the assessments that were made against the property that were based on items that you, as the tenant, were responsible for. And what you had said was, well, the property manager forgave my fines because of my cancer, but not their fines. And I'm not quite sure I understand that because my understanding is that HOAs don't deal with tenants, and that
So
the
they normally
HOAs,
don't.
hang on, still
Sorry,
talking.
sorry.
HOAs only directly communicate with the owners of the property. And when you say they waived my fines, are you saying that the property manager went in and removed fines that were due and owing by Mr. and Mrs. Terry on their property to the extent they were attributable to you?
Yes, ma'am. And Miss Terry actually got like her and I were texting back and forth, and I was like, she said she waived this, and she was like, oh, I see it on my ledger now.
Okay.
I'm also on the social committee of our uh subdivision. And I also there when we first moved in here, there was a problem with the teenagers at the pool smoking weed and having alcohol and stuff like that. And our police chief is a good friend of mine, so he would come and patrol and get his officers to patrol. So because I helped them out, they would give me grace, I guess you would say. And because I was on the social committee. And so like I had never seen, as I said, we stopped communication at 11/4. I've never seen half of these fines before in my life. Like I don't have any knowledge of them because we stopped talking on 11/4. And so something like the mailbox being turned, if I would have had notice of that, I would have just turned it the right way. And it wouldn't have been a big deal. So the thing that I question the most is painting the house. And I was looking at the because I've never seen these violations before.
Well, let me
Um,
save you. Hang on. So I really don't want to get into the weeds of a lot of this, okay? Because I
okay.
mean, what my review is focused on is the lease
Yes,
and the
ma'am.
obligations that belong to the owner and the obligations that belong to the tenant. And unless you requested that the property be painted and it was painted for you specifically, subject to some, pursuant to some agreement, I don't see a universe in which the lease puts the onus or the cost or expectation on you for the property painting. And so if that's something that is a matter of damage, I will hear
Yeah.
from the Terrys about why they think that is, your obligation, but I don't really feel like I need to go into it right now
Okay.
because the way this works is you're telling me your side. I'm going to hear from the Terrys. And then technically, because you are the person seeking relief, you would be entitled to sort of have the last word. And so if the Terrys raise those kinds of issues, you'd be able to respond to them.
Okay.
But on its face, at least, nothing that I see in the lease agreement and nothing that I am familiar with in terms of generally understood rights and obligations of a tenant would place the burden on the tenant to paint a property. But anyway, go ahead, Ms. Marzarati.
Okay. Going back to the inspection and the things that were listed by Officer Hightower, um, that's part of their damage claim. But everything that they listed was the stuff that Officer Hightower had fined them for. And so I don't feel like I'm financially responsible for the stuff that the housing authority told them they had to fix.
So
Um,
again, what matters is not whether the housing authority told them to fix it. What
okay.
matters is whose obligation was it to maintain that thing, right? And so, for example, generally speaking, as I understand the lease agreement language, Ms. Marzarati, you're not responsible for the appliances, which would include the refrigerator.
Okay.
However, the Terrys have at least made we call it a prima facie showing. They've at least provided some evidence to the court that perhaps the damage to the refrigerator was the result of misuse in some manner. And so we talked about that a little bit. And the reason I mention that is I'll hear from the Terrys in a moment,
Okay.
What I need you to focus on is, are there items? I need you to focus on the lease doesn't say I'm responsible for that. No agreement says I'm
Okay.
responsible for that, other than just, I don't think that's fair.
Okay.
Because the involvement of the housing authority is not really my concern.
Okay.
Um, my concern is there's a lease agreement, there's a contract between the two of you, the parties. And the question is, whose obligation was it to do X? And if X wasn't done, then who failed to complete their obligation? And if
Okay.
an HOA violation and assessment resulted from that, then who's responsible for it? Because who was responsible for the underlying thing? For
Got it.
example, I haven't gotten down into the weeds of the timing of all these assessments, but for example, if the, excuse me, if the Terrys were fined for refuse being on the lawn, which is one of the things, on the street for an excessive period of time. And that's one of the things they've provided me with a document that indicates, and they can show me in their invoice where they were assessed for that, and they can not, and no one can point to some place where it was forgiven or refunded or whatever. Then that's one thing for me to consider. And the question will be, who was responsible for making sure that that refuse wasn't on the lawn? That's just an example, but
Mhm.
that's sort of what I'm trying to focus my efforts on. Go ahead, Ms. Margiotti.
So some of this stuff, like this heater that is there, that was here before we even got to the house. So some of this stuff was here before we got there. And so this heating thing that they keep saying, getting fined for, this was here. This is all their stuff. That's not me at all.
But you control the property, right?
Well, I asked her
So I
if
mean, I
she
mean,
was.
I'm just asking, and this isn't a legal question. It's just a factual, trying to understand it from a human perspective. If you're being told that this piece of property, that this piece of refuse on the lawn is a problem, and you control the property, why don't you just get rid of it?
I wasn't told that. I wasn't, that's what
Okay.
I'm saying. The notifications that you got with all of the fines and stuff like that,
Mhm.
this is the first time that I'm seeing those letters.
Okay. So
I've
you're
never seen
saying
those.
that the Terrys never advised you that they were receiving HOA assessments for
So
things
she
that
would
you were.
say, "Oh, I got this."
Again, I'm
Sorry,
talking. I
sorry.
understand that you're
Sorry.
anticipating my question.
I'm
I
sorry.
don't think you're doing it on purpose to be rude, but I am asking you to please take a breath and let me finish my question.
Thank you. I'm sorry.
So you're saying that the Terrys never, when I read those text messages, when I read the emails in detail, you're saying to me that Miss Terry never told you that they had received HOA assessments for which they were responsible, that they thought you should have to pay because of various HOA violations for things that you were responsible for. You're saying they never told you that.
I'm saying that I got one about the driveway needing to be washed. And so I got that power washed. And then I would get something, Miss Terry would be like, "Oh, we just got an HOA thing for the yard. It needs to be mowed." But I've never seen the documents that you saw with the actual, okay, this is what the violation is and this is what needs to be fixed. I have never seen those letters up until now.
That wasn't my question. I didn't ask you if you'd seen the letters. My question, it sounds like what you're saying is that Ms. Terry occasionally told you that there'd been a violation related to the yard, you needed to cut it. She might have told you there was a violation related to something else, informally, by text, by phone, whatever. And I think that what you're saying is that she never told you that there was an assessment for refuse on the lawn or the crooked mailbox. But that's a different question than saying, did she ever tell you that? And your answer is, I've never seen those assessment notices. That wasn't my question.
Okay, so I never knew about the mailbox at all.
Okay.
I've never known about the backyard. I was always told about the front yard.
Mhm.
And once they came to the house, was like, "Oh, the backyard is a mess. You need to do
Who's
something."
they? Do you mean the
Mr. Terry,
Terrys?
yes.
Okay.
So like these notifications, like the mailbox. Let's take the mailbox for an example. Had I have known, I definitely would have turned that mailbox. Like,
Right. You've already said that. We can move on.
there's no text messages ever telling me about the mailbox.
Okay.
Um, Do you have any other questions for me about the fridge or the stove or the landscaping? Because you said the painting, I'm not liable for. And the things that Officer Hightower fined them for, the plumbing system failing. So there's no way my daughter could have, and I sent you a video of the plumber, it was rusted, and so that's why the water wasn't coming out. There's nothing my daughter could have done to rust pipes that are behind like a.
So let me, again, my understanding is that there is an initial inspection that was done by the housing authority that identified what it said were shortcomings in the condition of the property that either made it uninhabitable or were shortcomings that needed to be remedied by the owner of the property. I understand that's what the housing authority did. As to the particular plumbing, I know from the package that I've received from the Terrys that they have some argument that was again a tenant maintenance issue. Whether it was or not, I don't know yet. But that's why I asked you the question about. I'm not as interested in what the housing authority notice said. What I'm interested in is that the Terrys have said that you owe them money for certain things.
Right.
And so what I'm asking you to tell me is, why do you believe that you don't owe that? Now, we've talked about the stove, we've talked about the refrigerator, we've talked about the painting. I think you mentioned something about the landscaping. And I hope or assume that by that you mean something other than paying a yard company to mow the lawn. So
It's
if you
the
want to
tree
address the
trimming. They
landscaping.
wanted them to cut down the trees around the house because
Okay.
animals were able to run on the roof and stuff like that. And they said it was a hazard. So they had them cut the trees around the house.
Okay, and whose obligation do you believe that was based on the lease?
Theirs.
Okay, go ahead.
I believe I'm liable for the mowing of the yard, but not something like tree trimming. And again, one of the things that they said we were liable for was my daughter's bathroom, which I sent the videos and the pipes were rusted, and there's nothing we could have done to rust 20-year-old pipes that are behind the plastic part of the bathtub. We would had to have gone into the wall like the plumber did. And he couldn't even get the thing out. Like he had to go back and get more tools, like he says in the video, so that he could get it out because it was so badly rusted. So I don't feel that is that we are negligent for that. And I believe those were the receipts they gave you. So to go back to my claim about the amenities, I did go and look up. So the amenities, when you drive in, there's a clubhouse, and behind the clubhouse is a pool that has a water slide. And then there's a gym in the clubhouse. And then there's also a tennis court and a basketball court. And so I looked up 3 different memberships for like if we were to have paid for them at Lifetime Fitness, at the YMCA, and at LA Fitness, which is the closest gym to our house.
Hang on. Aren't you entitled to use those just because you live in the neighborhood?
No, not if your HOA fees are behind.
No, I understand that. But my point is, if you live in the neighborhood, you are entitled to use the amenities of the neighborhood. But again, your HOA fees have to be current, correct?
Yes. So that's why we chose this neighborhood, because my daughter loved these amenities and wanted to live here with her friends and go to the pool and all that kind of stuff. And we were denied access because they have always been in the rears.
Okay,
so there was one summer.
When did you first try to use the amenities and were told that you could not?
So the first summer we were here, the HOA president, like I sent you.
Which would have been in 2023?
Yeah, that was the only time we were able to use it. She waived it for us. And so we haven't been able to use it since then. So literally we've been living here for 3 years and not been able to use it.
Okay. And did you inquire with the Terrys about what the HOA fees were for?
Yes, and she told me it was my fault that it was the grass. And now that we have the ledger, I can see it was It was not paid before. The HOA president that told me they were in the rears before I got there was correct, according to their ledger.
Okay, and if you were, based on the ledger that has been provided, it sounds like you've had a chance to go and look at it. Have you been able to identify if some or any of those charges were removed
Yes.
or waived by the property management company?
Yes. So do you see how there's no charges on here well, actually, this starts in 2025, so this ledger isn't even accurate either, because we moved in here in 2023. But yes,
Okay.
Miss Terry has acknowledged that they did, in her text messages, that they did waive some of the fees.
Okay. And so I think where I interrupted you to ask a few questions, you were telling me about the value of those amenities, some evidence you wanted to offer me about the value of those amenities that you were not allowed to access in the summer or while you lived there, at least after the summer of 2023.
Yes, ma'am. So the amenities ranged from $500 a month at Lifetime Fitness to $139 a month at the YMCA. And so I had felt that $250 a month was reasonable for not having a proper working kitchen and the amenities.
Okay. For what period of time?
For 36 months.
From when to when?
Actually, my months are wrong. It should be from August of 2023 till the present for the amenities. And for the stove top and the refrigerator, the stovetop has never worked from April of 2023 to currently. And the fridge got fixed in late July, August.
Okay.
So the Officer Hightower from the Housing Authority also had there was a wasp's nest at the front of the house.
Again, Ms. Marzorati, I don't want to hear about that HOA opinion anymore. It's clear to me that, it's clear to me that there were some problems with the condition of the house. The reason those things might matter to this hearing is, Judge, there was a wasp's nest that the Terrys caused to be removed, and they're trying to make me pay for it, right? I think that's what you're saying.
That is
but
what I'm saying.
And you don't think you should be responsible for that because?
Because it's a wasp's nest, and I mean, I paid for it. I paid the $250 to have it removed, and I included the bill in my packet, or the receipt of the bill. And then there was
so you don't believe that that is part of the routine maintenance of the house?
No.
Okay, go ahead.
Because the problem occurred before we even got there. There's always been wasp issues.
Well, that's because insects are in Georgia, right?
Yeah.
I mean, I don't mean to be flip, but like,
No.
there are bugs, and and so I still question why that would not be the obligation of the person who's in possession of the home, particularly where, there are safety issues, right? If you're coming and going from the house, you don't want to be worried about being stung by a wasp and things like that. But please go ahead, Mr. Marzorati. Ms. Marzorati, I'm sorry.
It's okay. So I leave out of the garage, and so I truthfully didn't even know the wasp nest was there, because I never come through the front door until recently. And there was poison ivy at the house before we got there that I had to pay to get rid of, and I included that receipt too. I feel like
is that not part of the maintenance of the yard?
No, because it was there before we got there. So this was actually granted from the last judge too. He gave me the wasp nest and the poison ivy, but he did not give me the washer dryer. But the poison ivy was there, and there's text messages between myself and Miss Terry where she's like, "Oh, we don't even have poison ivy in Georgia. That can't be right." And then when it was right, and I sent her the pictures, which you have copies of.
Well, just like there are insects in Georgia, there's also poison ivy in Georgia. But
Definitely is. So that
if
cost
it
me
is
eight hundred
part of the
dollars.
yard, then, you know,
But it
um,
was there before we got there.
right, I understand that, but that's why there's, I think, at least 3 paragraphs in your lease that talk about your right to inspect the property. And once you inspect the property, you're right, you accept it as is. That's why I asked those questions
Okay.
at the beginning of the hearing.
So the washer and the dryer was working, but the washer was not. So I had to purchase a new one and have it delivered. And so I bought a used one off of Facebook Marketplace. I included those receipts and had to pay
Those
for the
belong to you,
removal.
do they not?
They do, but I also
Right,
had
so
to pay
when
for
you
the
leave, you
removal.
can take them with you, correct?
Absolutely.
Okay, so why, unless the Terrys want to buy it from you, why would they be responsible for the cost of that?
Because there was a washer and dryer in there, and the lease says if there's any appliances in there, then they're responsible for fixing or taking care of them.
I don't disagree with you that they were probably responsible for repairing or replacing the washer or dryer. But when you undertook to buy a new one that now belongs to you, I'm not sure how I'm supposed to make them pay for a brand new washer that belongs to you. Unless what you're saying is if they pay me for it, then I'll leave it there and it belongs to them.
Well, she didn't give me, she was like, you have to buy a new one. I'm not fixing this. And so I had no choice. And then she was supposed to have a guy come and take the old ones out. And he kept canceling on her. And so I had to pay for the old ones to be removed too. There's $150 where I had to pay the guy to get rid of those so that the new ones could be brought in.
Okay.
I talked to you about the poison ivy and the fridge being broken. And so the last thing is the court costs that I asked you for.
And what are those court costs, ma'am?
$318.
And that's for the cost of filing the appeal?
Yes, ma'am.
Okay.
And there's a receipt in your packet too.
Okay. And so what is the total amount of damages that you are seeking in this matter, Ms. Marzarezzi?
$24,500, Your Honor. And I did a ledger for you.
24,000.
$500. It was
Thank you.
10,300 was the late fee. The fridge and the stovetop and the amenities. I did $250 a month for 36 months, which was $9,000. The wasp's nest was $250. The washer and dryer was $650. Fixing the poison ivy that was there before we moved in was $800. The spoiled food from the refrigerator being broken is $1,000, and court cost is $318.
Okay. And then regarding the issue of possession of the property, you understand that you are, so long as the court allows you to maintain possession of the property, that you're obligated to pay the monthly rent, correct? And to pay it
Yes, ma'am.
timely?
Can
Okay.
I ask this though? If we've already paid the last month's rent, would I pay May, or is that because we've already paid it to them and it's in their paperwork and my paperwork?
When you say you've already paid it to them, do you mean independently or do you mean as a part of your initial? I mean, usually when someone moves in, they do first and last months. And are you saying that that's something you paid at the outset?
Yes, ma'am. So we paid 10,500 as a deposit, and then first month's and last month's,
Okay.
and a cat fee, a cat
Okay.
deposit because we have a cat.
So I I don't know the answer. Legally, I'm not going to give you any legal advice in terms of what you can or cannot do. Typically, what I would expect when a relationship has not gone as far south as this one has is that the parties would negotiate, hey, look, just keep my last month's rent, or I'm guessing that in a moment when I hear from the Terrys, I'm going to hear them say that they're entitled to offset it against the damages to the house or the damages they've incurred or the HOA assessments or whatever. And so I can't really answer that question for you in terms of whether you are legally obligated to pay the rent for the month of May. We'll get into the weeds of that in a moment.
Okay.
I'd like to hear what the Terrys have to say about it first. Do you have any other
One
questions
last
for me
thing.
right now, Miss? I'm sorry?
Yeah, one last thing. We did pay a $10,500 deposit on top of all of this.
Mhm.
So any damage that was done to the house once we leave, they have the $10,500 if they need to fix anything. Otherwise, I would like that money returned.
I understand, and I'm assuming that your contract says that you would be entitled to a reimbursement of that security deposit um, after offset for any damages that have to be properly documented. But that's something that occurs after you vacate the property,
Yes, ma'am.
and that's not an issue that's in front of me just now.
Okay.
Okay, thank you, Ms. Marzorati. Mr. and Ms. Terry, who am I going to hear from? Or actually, technically, Ms.
Yeah, my name.
Marzorati was testifying, and so you're entitled to ask her questions if you'd like to ask her questions, or you can simply present to me. This is a little less formal because it is just y'all and me rather than, a jury and lawyers and that sort of thing.
Okay, I understand. Again, my name is Ansel O'Neill. And Your Honor, we're deeply grateful for the court's order to disperse the registry funds. However, after following the court's directive to coordinate with fiscal services, we were informed that administrative processing will result in a 2 to 3 week delay before the funds are actually received. Because of these funds have not yet reached us, our status as sufferance remains acute. We continue to bear the full financial burden of this property while the petitioner remains in possession without providing any immediate relief. To prevent further uncompensated loss while we wait for the administrative process to catch up with the court's order, we respectfully request that the writ of possession be issued today. Additionally, we have updated our damages ledger to include a new $500 HOA fine received yesterday. Our final net judgment sought, accounting for the registry funds and the per diem holdover through today, is $21,505.59. As far as what Priya was saying, is as far as what you wanted to talk to her about damages and like
Yeah,
that.
we asked that Priya's claim be dismissed with prejudice. Under our lease agreement, washer and dryer, I do not provide. In our exhibit D, there's evidence that she asked about the washer and dryer because we were having things removed from the property. And she asked to keep those items because I informed her that those belonged to a previous tenant. And she said that she wanted to keep them. So by all means, you want to keep them, you can keep them, but we don't supply washer and dryer. It's not in our lease agreement. Pest control is specifically a responsibility of the tenant, which is also in our lease agreement. So I'm not responsible for poison ivy, wasp, or the tree cutting, even though we cut the tree. And we're still getting HOA fines based on her negligence to maintain the property. Trash, not cutting the backyard, not trimming the bushes on the side of the house.
Ms. Terry, can I ask you a few questions?
Yes.
Number one, about the issue. So one of the things I heard from Ms. Marzorati is that some of these things that you have provided me with documentation of HOA assessments for violations that you never told her about.
No.
And she conceded that you had told her about some things like the front yard and some other things, but she says you never told her about these things so that she could fix it. And at least as of November of last year, y'all really haven't been in communication at all. Can you address that for me, please?
Yes, she is aware. We had court on March 10th with the lower court magistrate John Frazier. These same items were brought up there and also displayed as evidence in court because we were in person at the time. And also, I've communicated with her prior to letting her know that she has to maintain the lawn. It needs to be cut more than once a month because she only tries to cut it once a month when it needs to be cut twice a month because the lawn grows rapidly, but she refuses to maintain the property in that sense. And that's a part of our lease agreement as where she is supposed to maintain the property interior and exterior at her own expense. And that includes lawn lawn care, which, right, the tree cutting, any bushes that need cutting, any type of poison ivy that needs to be removed. And right, you were right to mention when she signed the lease agreement, there is a clause in there for possession that states that she accepts the property as is. The list that she sent was after she had signed the lease agreement, but those things were just like nuanced things. So she said the toilet seat was broken. It wasn't broken. The screw underneath the toilet seat was loose. It just needed to be screwed so it could be tightened again. Right. She stated that the refrigerator was broken. The refrigerator wasn't broken until she broke the hinge from slamming the refrigerator door constantly. So we had to replace the hinge on there. And as well as that same appliance man had looked at the stove, and right, I did purchase a new stove, but chose not to install it until after she moves out because there's nothing wrong with the stove. The technician who was there.
I'd like to just interject a moment. The petitioner.
Nope.
Okay.
Sorry, Mr. Neal, this works one at a time. You guys were very polite and respectful, allowed Ms. Maserati to speak without interruption. I know y'all are working together, but
Yeah.
it really is helpful that I hear from one person at a time. So if you'll just make a note of what did you wanted to say, I'll give you an opportunity after I hear from Ms. Terry, okay? Thank you,
Okay.
sir. Go ahead, Ms. Terry.
So I wanted to just note that item was fixed. The refrigerator was cooling and freezing at that point, in which I told her it was only the front panel that wasn't working where you could get ice and water out of, but that's not important to me. As long as the refrigerator is cooling and freezing, it works. But the guy replaced the hinge on the door, and he also noted that, right, the eyes on the stove, they were fine, but I had
So
still
you're
paid.
saying, hang on, let me make sure I understand, Ms. Terry. You're saying that when you sent someone to go and inspect the property
This is
or to repair the stove, right, that they were able to make all four of the burners on the stove work and it worked appropriately, and he was not able to replicate what Ms. Maserati is complaining about even now.
okay. Let me step back because this is the thing. She conflated a lot of things. The things that she's speaking of are from 2023. So what I'm referencing right now is in 2023 when she first moved in. And right, I just had people come, maintenance men people come to look at the property and right, do certain things and at that moment. But now, fast forward to that July where she tried to use code enforcement to evade paying rent because she was late for that month of July. She paid rent on the 23rd of that month, which is after code enforcement's inspection. What her deal was, she was trying to use code enforcement as a means to evade eviction if I had filed in July, because she was going to say, oh, there's an open case and da 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 da. But even after that, code enforcement noted that, right, she is in possession of the property and it's not being maintained. And she is required as the tenant to maintain the property. And code enforcement noted that the property is not being maintained, which is obvious that it's not being maintained from the trash left around, the lawn not being cut. And right, when we had the maintenance, the plumber, and the technician come, which I'll speak to because we have a video of the technician stating that the stove works fine, the eyes are fine, but we still had him replace the eyes on the stove anyway, which you can see the receipt for, but it was due to grease buildup because she doesn't clean, she doesn't maintain the home. And also, right, the refrigerator not working properly because she keeps food beyond the normal storage capacity that a refrigerator could hold. There's a couple of pictures in our exhibit in our damages that show that. I believe, what is it, on page 50, 54, 55, those images. She's standing next to the refrigerator and you can see the refrigerator is completely full and her countertops are still filled with groceries, which is right. It's beyond normal to have for when it's just two people living in the house. But besides that, instead of dealing with that, we just replaced the whole refrigerator. And right, we have video that the stove is working, so we're not responsible for her food spoiling or any of that because the stove works just fine. She just
Terry,
doesn't know.
I'm sorry to interrupt you. Can I ask you a question, please?
Yes.
Um, Can you address the issue of the home inspector, the housing authority individual? I think
Yes,
it's Mr. Hightower.
yes,
Um, Ms. Marzorati has said that when Mr. Hightower came, my understanding of Mr. Hightower is that he is a person who works for a government agency,
yes.
who came to inspect, which presumably would be within his purview, and that you called the police on them. And then later, I know I heard from you in our last hearing that you did not hear back from Mr. Hightower, and there was some assertion one way or the other that either you had ghosted him or he had ghosted you or something like that. But clearly, you've not been in touch. Can you please address for me the circumstances of that and what you believe happened and why on that issue?
I do have messages from Hightower showing that he ghosted me. Basically, well, I don't know. Can I show you the text messages?
You can, at this point, I've allowed Ms. Marzorati to tell me what the text messages said, and so I will allow
Oh
you
no,
to do that.
no. These are
Just,
text messages between me and Mr. Hightower because
I
he's
understand
not
that.
on.
So Mr. Hightower is not here. The statements
Right.
that he made in those documents are out of court statements, which makes them hearsay.
Okay.
Um, but that's actually not my question. My question is, why did you call the police on them the first time?
So I didn't call the police on Priya. I called the police on Officer Hightower because she's in holdover. She was in default at the time, and they were supposed to call me to schedule an inspection of the property as the homeowner. And right, code enforcement can only inspect the property when there's an absolute emergency or an ambulance came out or police came out. They confirmed this inspection without my knowledge, then called me on the phone and said that they had inspected my property unbeknownst to me. Priya didn't even tell us that there were issues at the home. She just called code enforcement, lied about calling code enforcement to us, and said that her dad had actually called code enforcement. And he doesn't live there on
Did,
the property or whatever
so
excuse he gave.
did code enforcement know that, to your knowledge, that you were the owner of the property and that Ms. Marzorati was a renter?
Not until after he inspected the property. And once he found out that information, he
Mhm.
backed off and left it alone because technically, right, they violated our Fourth Amendment rights with he was supposed to have a search warrant in order to conduct that inspection.
Well, I'm not going to get down to the weeds of that. I don't actually think that's correct, ma'am. No, ma'am, Ms. Marzorati, make a note and you will have an opportunity to respond, just as I've told everyone else.
But
Um,
right, code enforcement closed that case in November 2024. We do not have any fines or citations from code enforcement at all.
okay. And is that because they declined to fine you, or is it because you undertook to remedy the things that were allegedly substandard about the property? Because it sounds like you did undertake to do those. Whether and why you did, I don't know. But it does sound like some of the issues that have been complained about that you did undertake to correct those issues.
Yes, I went on because like she's doing today, even though despite the stove and the refrigerator being replaced, if they were to come out, they would still say, she was still going to say that the refrigerator is broken, the stove is broken, which isn't true. But yes, he decided not to come out or he ghosted me. He didn't reply to my message when I asked him the status of the case and could they close it. And that was last year. But that's between the messages between me and Officer Hightower because we had shared conversation together because I asked him, the plumber was confused. He came out, he said, I don't understand why code enforcement is being called. It's clear that the tenant broke the handle and the glued down stopper in the sink. So he replaced that, but all the other plumbing or everything else is fine in the home.
Okay.
In the home.
Let me ask you a couple of other questions. So, it sounds to me as if there's not a dispute that Ms. Marzorati was not able to access the um, amenities because of HOA assessments that were outstanding. Ms. Marzorati's argument is that you were actually always in arrears on your assessments for reasons that had nothing to do with any violations that she committed. Can you address that for me, Ms. Terry?
Yes, I was not always in arrears. Otherwise, I wouldn't have been able to provide her with the pool keys and the access fobs. Now, she has the pool keys and the access fobs for the property, but right, I do not have control over shutting those fobs off. Whenever there's a violation or HOA says there's a violation on the property, right, they'll give you friendly reminders. Then they will move to fine you, which has happened. They sent friendly reminders. I've asked Priya constantly to keep the grass cut and maintain the property, which she fails to do, and the HOA continues to fine. And
So
since I have those fines,
but I guess my question is, are those assessments, um, if you were, I think I've seen something that looks like a ledger from the HOA. I don't know if it was from Ms. Marzarati or from you or both. If I were to review that, is there a way for me to know if it is a, for example, late fee assessment? Because like,
yeah,
here's
you
your
can
monthly
see,
is, hang on,
yes,
I'll tell
I'm
you the same
sorry.
thing I told Ms. Marzarati. I know it's an awkward way of communicating, and I know you know what my question is, but let me just answer it all, ask it all the way. So I see these types of invoices quite frequently for HOA cases. And, you know, there are, say, monthly HOA fees that every person who owns a property in that location is required to pay. And maybe it's $200 a month or something, right? And if you don't pay it, there's a late fee. And so now maybe you owe $250 for that month. And that continues to accrue. And then sometimes you get an assessment for a violation of the rules, which I know is an issue here. For example, having the yard be uncut or having the mailbox be misconfigured, that sort of thing. So if I were to look at the invoices, the ledgers, is there a way for me to tell that something is for a violation as opposed to a failure to pay a monthly assessment?
Yes, it is. I highlighted all the fines that we are asking for and seeking. We did not highlight any of the assessment fees or any of that. We just highlighted the violation fines, which we are requesting that she is responsible, that
Right.
we're
And
to
I'm
be
not
responsible
necessarily
for.
disputing that. I don't know why my Zoom is suddenly being weird and going in and out of focus. I'm sorry. Um, I'm not actually disputing that. That's not really my question. My question is two things. Number one is, are any does that ledger reflect that at any time the amenities were not available because of assessments that were attributable to you that were not paid? Not
No,
assessments that were attributable to Ms. Marzarati, but to you.
no.
Okay.
We were in 2023, she received the pool keys, and
Mhm.
then there were fines for the lawn. Those in
For the lawn.
2023,
Okay.
yes, those in 2023, those were waived. But Priya pays rent late every single month since the
Mhm.
beginning of this lease agreement.
Right.
Because she pays rent late every month, what say would be a regular maintenance fee on the property are now our personal fees increase. So yes, there are fees for like the HOA dues that have been paid late, and that are still some that are hard to pay because we're not receiving any money. So there
Okay.
is a
So
balance now,
I
but
absolutely understand why her paying you late might result in you paying your HOA assessments, your routine regular HOA assessments late. I
right.
understand those two. But it also sounds like whatever the reason, there are at least occasions where you're paying your HOA assessment late that might result in the amenities not being available to you as the homeowner or to Ms. Marzarati as the person possessing the property. Is that right?
No, we're current. We pay.
You're
The
current
only thing,
now. But my question was,
no, we're not current
were there
now because
periods of
there,
time during her living in that property where the amenities were not available to her because of your failure to pay routine assessments, not failure
no,
to pay assessments attributable to Ms. Marzarati?
no.
She does.
Okay.
That's why she was able to have the key fob and able to have access
In the
when she,
summer when she first moved in, is what she
right.
said to me. But
Mhm.
then after that, she says she's not been able to use the property really anytime after the summer of 23.
Correct, because of the fines that she's incurred on the property due to her not maintaining it.
Okay, and then that was my second question is um, when I go and look at the ledger that you've provided where you've marked it up, Are any of the assessments that you are seeking recovery for, is there any indication that those assessments were forgiven by the HOA? And I say that with air quotes because I don't exactly, I mean, I know the property managers have the ability to just zero them out and write them off, but typically they come with some sort of documentation. I don't know.
Not
Ms.
for
Terry?
this year. No, the
Okay.
waiver that she's talking about was from 2023, which is what she's talking about. But what we're asking for is from June 2025 until now. So we're not even talking about what she was talking about was 3 years ago. What we're
Okay.
asking for is current.
Okay. Okay. And what what are the damages that you are seeking in terms of a judgment amount? Um, and I haven't been able to get all the way through the documents. I've seen a number of the documents you've provided, but have you provided me with a ledger of your own that sort of itemizes the specific damages?
Yes, this morning, I had sent Michael Freehoff an email. I'm sorry, I said his name wrong. I am
That's
so
okay.
sorry.
I knew his last name's unique enough. I was pretty sure who you were talking about. So
Okay, okay, Mitchell. Yes, I sent him an updated ledger that includes the $500 fines that we received in the mail yesterday due to her not cutting the bushes on the side of the house, excuse me, and the backyard. So the final net judgment less the registry funds is $21,505.59. But yes, there is an itemized list if you would like us to share it in the chat or share our
um,
screen, if you would.
so what I'm looking at in your packet that you sent is a document that has a total of about $18,000 on it. And so I want to make sure I'm looking at, so the document that I received this morning is a two-page document, one which seems to be the two new assessments.
Yes,
But I don't know.
there was a ledger attached with that as well, a updated ledger.
Should be April 17th hearing, you updated ledger.
It should say finalized item damages ledger updated to
Yes, I
April
see it now. It was
7th. Okay,
in black, and so I thought it was like a photograph, and so it
I'm
was difficult
sorry.
for me. That's
Yeah.
fine. It's a screenshot of a computer screen, I think,
Right.
so that's fine.
Yeah.
Okay, and so and I understand you've not been able to receive those funds yet, and for that I am sorry. But
Okay.
some of this amount, the way you get to that 21,000 is that some of that amount would be offset by that 17,000. Is that correct? That is in the registry of the court?
Correct.
Okay. Okay. Is there anything else? I know Mr. Neal had wanted to speak for a moment. Is there anything else that either of you wanted to say? I'm sorry, sir.
Not exactly. I just wanted to follow up with Miss Terry, what she was saying as far as like the appliances. I just wanted to basically say her counterclaim regarding the appliances have been proven factually incorrect by our video evidence and the technician reports. Like in the video, the technician is literally telling her every spark module works on each eye. And in the second video, she's literally turning on the knobs and the fire comes on. And she said, oh, that usually never happens. The stove never usually ever works. But then in the video, while I'm filming her, it came on. And that was probably the second time a stove technician came out. The third time a stove technician came out, he said there's literally nothing wrong with the stove besides it's just not maintained well, and there's a lot of buildup and grease built up in here, and it just needs to be cleaned. But I'll still replace the spark modules, and I'll refund you for that. But that was really the only thing I wanted to just highlight because the lie had to be disproven.
Understood, Mr. Neal. I wanted to ask you, at the beginning of this hearing, Ms. Marzorati had mentioned that um, separate and apart from any judgment amounts that the court might be entering in this case against one or the other of you or both, which is, I guess, what the lower court did. The issue of possession is still one that remains. And Ms. Marzorati had offered to agree to terminate the lease. I mean, not, it's already terminated. She's a tenant holdover, but agree to voluntarily vacate the premises as of, I guess, the last day of May. And then there was some discussion about whether or not she needed to pay rent for the month of May, if in fact, and that was really my question. Let me start with that, is when she moved in, did she pay you first and last month's rent? And what was your expectation, if setting aside the difficulties that have accrued, right? What was your expectation for a tenant if they were to say, hey, I'm moving out May 31st, but I already gave you last month's rent, so I don't have to pay you rent for May? Is that something you would agree with or not agree with?
Not typically, because her lease agreement, if everything would have went well, it would have ended April. So May would still be outside of the 3-year lease agreement we have originally had we had no issue with her at all. So I wouldn't.
Well, no, I understand that,
Mhm.
but still,
I wouldn't have an
she,
issue. Oh, go ahead. I'm sorry.
right, her assertion is that she already gave you $3,500 that was supposed to be for the last month she was in the property. And so whatever that last month is, and whether she was contractually or legally obligated to be there, the question is, does she have do you in fact still have the 3,500? Like, you don't have to tell me if you have it. That's not what
Yeah.
I mean. Do you, if she were to stay in the property for one more month, are you expecting her to pay you for another month, or do you have
No,
the
she has.
$3,500 that she paid you as first and last month's and security deposit?
Yes, we are still expecting a payment because she's in holdover is double the rate. So it's not just the base rent at 3,500. It would actually be $7,000 per month.
Okay. And tell me where in the lease agreement there is a provision that says that.
So the holdover clause is on, let me see real second. Let me get the page number for you.
It is the 5th page of the document. I am looking at
Yes.
it now. Okay. Thank you. I understand that. I understand your position now. Thank you for directing me to that provision. And so part of the basis for your damages is that you believe, since when was the holdover lease applicable, and for what months did Ms. Marzorati owe you double the rent?
December 2000.
December 2025, all the way up until currently till today through April 17th.
And was that part of the judgment that you were given by Judge Frazier in the lower court, or was
No.
that judgment based on $3,500 a month?
It was based on the $3,500 a month.
You didn't agree to
Okay.
all.
And to be clear, I want to distinguish, because legally the requirement for Ms. Marzorati to maintain possession while she's appealing, I understand that amount is $3,500. But the
Yes, we did the
judgment that Judge Frazier granted you, did he grant you, I think it was back rent in the amount of 14,000? Was that for those months that you're talking about, December to whenever that judgment was in March, at the $3,500?
Yes.
Okay. 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 And I think those are all of the questions that I had. Did you have anything else that you wanted to address with me, Ms. Terry or Mr. Neal, before I give Ms. Marzorati an opportunity to have the sort of last word? Because as the petitioner, she is entitled to that last word.
I think we've covered everything from the pest control to the property maintenance to the HOA fees. So I'm okay. Besides, right, we would just like the writ to be issued, her claims dismissed, and ours granted.
Okay. Thank you very much. Ms. Marzorati, it is your opportunity to respond now, ma'am.
The last judge said that so the lease was written by Miss Terry, and she had the dates wrong on the second page, if you look. And so he said that if they don't qualify for the holdover, the lease was not terminated because it didn't end when it said it did based on her lease and the way that she wrote it. And he refused to give them double the rent. So I'd like to put that into record, that everything was just $3,500.
Okay.
The agreed upon late fees, again, as I've said, I did not agree to pay $500. I've agreed to pay $100. The HOA, if you actually look on the ledger, they make one payment and then another payment. Like the first payment they make was on 4/19/25, and then they make another one 11/26/95. So they have collection attorney's fees, they have interest, they have a whole bunch of stuff on here that would make us unable to utilize the pool and the amenities. So this is not because of my fines. They have never been up to date or paid it. The stovetop video, I sent you one this morning so that you guys could see. It's still not working. Only one lit up. So when they're saying that the stove works fine, oh, I did order a new one, but I didn't put it in or any of that stuff, it's not true. It's not my.
But that's not the only thing they said. They also said that there's a video that they've provided as part of their evidence that they sent a technician there, and that when the technician was there, all 4 burners worked.
No, all 4 burners did not work. We still had to manually light 2 of them, I think, in that video. I don't remember, but it's never worked since we've lived in this house. It has never worked. Not all 4 burners. And so that's why I sent you a video this morning, so you could see I'm literally, lighting all 4, turning all 4 of them on, and they're still not working. There's no way that I could break these burners like that. It's just an old stove. It's been here for like over 20 years. It needs to be replaced. And she acknowledged it needed to be replaced. And that she bought a new one. Also, I'd like to also point out again that we stopped communication 11/4. So the fines and stuff like that after 11/4, I was not given any knowledge of. I'm trying to see what else they. Property damage.
So I understand that you stopped communicating directly with the landlords in November, but I think I understood Ms. Terry to be saying that some of this information you would have been made aware of at the hearing in March in the magistrate court, correct?
Correct.
No.
Nope. Ms. Terry, y'all stay muted. Y'all, no, there's no opportunity for you to talk right now. Go ahead.
So I didn't. The first time that I've gotten their all of their packet of information and stuff like that was for your court hearing. So I was told about stuff at the other court hearing, but I have never received like a letter like this.
So again, Ms. Marzorati, you continue to say you'd not seen these documents, but that was not my question.
Sorry.
You originally said you didn't know about any of those violations or assessments. And what I was saying is Ms. Terry's response to that was, even though you weren't in direct communication, at least in March, when the hearing was in this original dispute in the magistrate court, you were aware of them then, correct? If you had not been aware of them before.
But even the judge threw those out then because I was not given any notice, like up until that hearing. Then they're like, okay, well, this is what she owes for this and this and this. I wasn't.
Okay, so procedurally, it is important that everyone understand that the way this works is this is not an appeal in the true sense that I am limited in what I can consider, right?
Okay.
When you appeal the magistrate judge's decision, you basically start over again.
Okay.
If you didn't start over again, then I would just review the evidence that was presented to the magistrate and say, yeah, I think he's right, or no, I don't think he's right. So that's not what this is. And so while I have great respect for Judge Frazier, and I think he does a good job, it's my job to hear the evidence that is being presented to me here now and make a decision on the merits. And so while Judge Frazier might have said, Ms. Marzorati didn't know about these things in March before the day we showed up for the hearing, so that's not fair, I'm not going to allow them. You've known about them since March. So the same logic doesn't necessarily hold.
But I didn't know how much it was, what it was for, or anything until I got the letter and the paperwork. So like even their new claim that they have that they added $500, I have no knowledge of this. I have not seen any of like the new whatever. And the lawn was just cut, and I included new pictures of the lawns so that you could see like it's been cut, it's perfect, it looks great. So you could see like it's been maintained.
Okay. What about the shrubs on the side of the building, right? It's allegedly a photograph that was taken,
So I had no
and
knowledge of that.
you don't
I
have any
didn't
knowledge of what the shrubs on the side of your house look like?
no, I didn't know that they needed to be trimmed or anything. She did the grass and all of that stuff because I knew that needed to be maintained, but I had no knowledge of any, like if she would have told me just like the mailboxes, hey, you need to turn the mailbox, then it would have been fixed. But I didn't know that the shrubs needed to be cut. Otherwise, when Janella came, I would have had her do that.
Okay. Okay. So what what okay. I think Ms. Terry, I think you had raised your hand at one point that there was something you wanted to add if it's brief.
Yeah, I forgot to mention about the text messages for the agreed upon late fees that I had evidence for. I forgot to mention that earlier because right, she agreed to the late fees in Exhibit A. You could see a conversation between me and Priya and Gerald Boyd, who was also on the lease agreement, as well as a paying tenant who paid at a certain point in time, where I explained the late fees to them. And that was back in 2024. They had no objection to it. They could have objected right there, but instead he says thanks for the clarity that he will make a payment today. They could have broke the lease or said, we disagree with this, we want to move. At any point in time, she's free to break the lease or move if she wants to. Nobody's holding her hostage. She just has
I
to.
understand that, Ms. Terry. I will
Yeah.
tell you, though, that my review of your lease agreement, which Judge Frazier was correct to note, was written by you.
Yes.
Because it matters for how it's considered by the court. It contains an entire agreement provision, and it contains a provision that says there are no additional terms or conditions that will be added. And so, generally speaking, what provisions like that in a lease mean is that you can't change the terms of the lease without actually amending the lease. And while your argument that you told her you were going to do this and she may very well have waived her rights by not objecting and by consenting and paying in certain circumstances, I'm not sure that's enforceable because, again, that would be an external agreement to the contract. I'm not telling you that's my ruling right now. I'm just telling you that based on what I read in the contract and what I understand to be the relevant law, I'm not sure that would be an enforceable change to the terms and conditions of the lease because it wasn't done through an amendment to the lease.
Um, it was a discussion that we had, like a verbal agreement, but I do believe our lease agreement does allow for verbal agreements to take place. Let me see.
No provision of this agreement shall be considered waived unless such a waiver shall be expressed in writing as a formal amendment to this agreement and executed by the tenant and landlord. I understand that is a bitter pill to swallow for many people because that's not how people function in real life. But it is my job legally, right? The thing that controls this relationship is the written contract. And I'm just telling you that as I read that contract, I suspect that that's why Judge Frazier did not allow for the additional, even though you can document that you told her you were going to do it. And perhaps even she paid it in certain instances. I'm not sure that the contract allows you to change the late fee provision without a formal amendment or at least in writing.
It
Um,
wasn't a change.
so,
It was more so an explanation of how the late fee works because it's noted that it's $100 per occurrence in our lease agreement. And I was explaining how that a per occurrence works in those messages to Priya and Gerald Boyd.
well, and
And
I will take a look at those provisions. I'm not saying that I'm fully discounting
yeah,
them. I'm just
yeah,
trying to be
yeah,
candid about, that my review of the
right.
agreement it is that it would need to be in writing if it's going to be something different than what is in the agreement, which is $100 a month. But perhaps that per occurrence, as I said, the court will look at that in some detail and let you know.
Okay.
Is there
Okay.
anything else you wanted to add, Miss Terry?
No, that was
Okay, Ms. Marzarati, I did tell you that I would let you have the last word, so.
Thank you, ma'am. I would like to also add that, again, as everybody knows, I have cancer. Miss Terry knew before we moved into the apartment, I sent you the text or the house that I
Ms.
had cancer.
Marzarati, I'm very sorry that you are struggling with cancer, but I'm not sure
Oh,
how
can I
it
finish my?
affects.
I
Excuse
just
me?
wanted to say, so that's why I would rather I'd rather have paid than argue with her. I just didn't have the energy at the time going through treatment to be like, no, the lease says $100. So for peace sake, I asked her, and every time I got a response of you pay it or you get evicted, I didn't want to get evicted because I have cancer and I have a daughter. And so I feel like I paid it under duress, not like willingly, but under the guise of, okay, if you don't pay it, you're going to get evicted.
I understand your concerns, ma'am.
Thank you.
Anything else?
Um, I'm still, so I would like to add the 3,500 for the last month's rent to my judgment, if possible, if I'm not allowed to stay in the house. Because we've already paid that last month's rent for May.
Okay. So I feel like Mr. Neal and Miss Terry, y'all are going to need to figure out what's going to happen. Like you're going to need to anticipate and give some thought to what's going to happen when Ms. Marzarati moves out of the house. Because no, ma'am, no,
I have
ma'am,
to throw up, ma'am.
you can step off camera.
Okay.
We will take a brief break.
I'm so sorry.
Ms. Maserati, are you feeling okay? Are you able
Yeah,
to
I'm
proceed?
okay. Yes, ma'am.
Okay. Okay, so I think where we left off and what I was saying is I think Mr. and Ms. Terry and Mr. Neal, I think you need to give some thought to what's going to happen when Ms. Maserati vacates the property. And here's why I say that. There are well understood obligations, both in the lease and in law, that require you to account for any funds that you have in your possession that were paid to you as part of first month's rent, last month's rent, or any security deposit, and then to account for any use of those funds that will not be returned to Ms. Maserati. And so the reason I say that you need to anticipate that is because it sounds like already what I'm hearing is whether I were to order Ms. Maserati to vacate the property effective on April the 30th, or whether I were to allow her to maintain possession of the property through May the 31st, which was her proposal. Um, it it seems like that is going to be an issue because one, given the condition of the house that you have complained about, I expect that you're going to seek to offset some amounts or all, whatever, of the security deposit that was paid. And two, it sounds like we can't even agree on whether she has paid the last month's rent, subject to this escalation clause that the court needs to look at. Um, and so, whatever my ruling is, in terms of giving you back possession of the property, I suspect that we are going to end up right back where we are on the disposition of those funds. And that's something that concerns me. And so I think the parties should be aware of that. Now, separate from the payment issue, which I know you are very sensitive to, particularly given that you've not been able to recover the payments that have been made into the fund, into the registry. If um, what are we're separate and apart from the payment issue. What are your thoughts on Ms. Maserati's offer to voluntarily leave the property at the end of May rather than pursuant to a writ of possession? And there are a couple things I want to mention in terms of your thought process. And if you want to think about it for a minute, you can tell me that. Um, if I enter a judgment sometime next week, which is truthfully as soon as I will be able to get to getting something drafted and entering an order. Um, Ms. Marzorati will have the opportunity to file an appeal. And during that appeal, she is, as long as she maintains the property, the rent is entitled to maintain possession of the property so long as that appeal is pending. And those appeals typically take a lot longer than this one has taken. And so, not for nothing, I can't give you legal advice, but not for nothing, it may be in your interest to consider at least allowing her to voluntarily leave the premises rather than pursuant to my writ of possession, because it may be that she's out faster, if that's what you actually are trying to accomplish. Because for my consideration, the issue of the monetary judgments that flow back and forth, I'm going to spend some time looking at that. But at the end of the day, there, the writ of possession that was previously entered by Judge Frazier is it is appropriate. There is the relationship has broken down such that Ms. Marzorati is a holdover tenant. There has been an effort to terminate the agreement, and so other than her rights to maintain possession pursuant to an appeal, I don't believe that Ms. Marzorati has any right or authority to possess the property. And so it is likely that what I would do is enter a writ of possession in favor of the owners of the property, Mr. Neal and Ms. Terry. And it would there's no dispute that Ms. Marzorati has paid the statutorily required rent for the month of April. And so if I enter a writ of possession, it's going to be through the month of April. And so it would require that she vacate the property on Thursday, April the 30th. And y'all would be entitled to a writ of possession that would take effect on May the 1st. And again, I don't know if there's going to be an appeal of that issue and how long that will take. But I mention those issues because I think given the combination of that issue and the combination of this dispute about the financial aspects of any funds that she paid as a security deposit or first and last month's rent, and whether and how those might be returned or not, and on what basis, those are going to be continuing issues that we'll have to deal with at a later point in this process after the court enters an order. Given those pieces of information that I'm providing to you, currently your request is that the court issue a writ of possession. That writ of possession would be effective as of May the 1st if I rule in your favor, and then the court would spend some time looking at the dollar amounts of the judgments that have been presented to me for consideration. What are your thoughts on that, Mr. Neal, Ms. Terry?
Can we have a couple of minutes to confer?
Absolutely. Yes,
Okay.
sir.
Come back. I wasn't trying to take more than 5 minutes.
Ms. Marzorati, are you there?
Yes,
Okay.
ma'am.
Mr. Neal and Ms. Terry, you mentioned that you wanted to take a moment to talk before you answer my question, which is, what are your thoughts on resolving the possession issue by agreement with Ms. Marzorati, where the parties, I would probably draft it for you since don't have lawyers, but it would essentially be a consent order where Ms. Marzorati agrees to give you a writ of possession effective May the 31st, or your actual date of possession would be effective January the 1st. And excuse me, I'm sorry, let me say that again. I'm sorry, I'm trying to do too many things at once. She would agree to move out by the 31st, and so she would agree to a consent order that gives you a writ of possession effective June the 1st, which is a Monday. And so that was the question I was asking you to discuss in terms of whether you still wish to pursue a request for a writ of possession either in stanter or through the end of the month, based on her having paid rent, albeit late. I know that's an issue that you have mentioned before. Or if you wanted to potentially agree to resolve that issue by agreement and then the court would sort out the money judgments issues. What are your thoughts, sir?
Uh, I was more inclined to probably just have for the writ of possession as early as possible. So I guess that would be May 1st, only because she can file an appeal, yes, but she could also do that if I asked her to stay voluntarily until May 31st, and she could also try to maybe do the appeal thing
Well,
again.
again, can't give you legal advice, but if it's a consent order, right, where Ms. Marzorati is agreeing to it, which this hearing, she's the one that mentioned it. Any order that I enter would say that the parties specifically agree. You generally can't appeal an agreed order. I don't know what error there would be. Now, you could still appeal the issue of the any judgment amount I enter in favor of you or any judgment I enter in favor of Ms. Maserati, but the issue of possession, I don't think would be subject to appeal further. But again, I cannot give you all legal advice. So it's entirely up to you. And whatever choice you make, you are legally entitled to make that choice. And so I'm not telling you what choice to make or not. I do just want to make sure you understand that one consideration you mentioned about what choice you might make, I don't think was legally accurate, which is that if it were a consent order, and Ms. Marzorati, I am framing that correctly, it was your offer that you would agree to a consent order that says that the Mr. Neal and Ms. Terry are entitled to retake possession of the property effective June the 1st.
Yes, ma'am.
Okay.
Appeals. So, hold on, Your Honor. She could file an appeal. She can't file an appeal based on a consent order, but there is no, there wouldn't be room for appeal either way. Never mind.
So just for y'all's I'm sorry, Mr. Neal, what?
My concern is the squatter risk, because if I don't have the writ already in hand and I wait for her to voluntarily leave on the 31st and she just simply refuses to leave, I would have to file a new motion for contempt or a new request for a writ, and that could take another 2 to 4 weeks as well.
That's absolutely true. I can't swear to you that Ms. Marzorati is going to leave on June the 1st, or I guess May the 31st. What I can tell you is that I believe that the timelines for you to accomplish something, if that were to happen, would still be shorter than if Ms. Marzorati were to appeal a writ of possession. Understand that although they get rolled up together, the right to possess the house is a completely separate and distinct legal right and remedy than the ability to enforce a money judgment one way or the other, whether it's you trying to enforce a money judgment against her or her trying to enforce a money judgment against you.
Okay, so
here's what I'm going to do, Mr. Neal, is instead of putting you on the spot right now, what I'm going to ask you to do is I'm going to ask each party to email the court. And Ms. Marzorati, I'm actually going to ask you to start to initiate that first email to document the offer that you made on this call, on this hearing, which is that you would be willing to enter into a consent order regarding possession of the property effective June the 1st. You would have possession. Your last day would be May 31st, and Mr. Neal and Ms. Terry would retake possession effective June 1st. And then Mr. Neal and Ms. Terry, you could respond and let me know your response to that and whether you are willing to accept that offer and also enter into a consent order, or whether you request the court that as part of its consideration of a money judgment, that the court also consider the writ of possession that you have sought in this case. Does that make sense, Mr. Neal?
Yes, it makes sense. I'm not totally opposed to the consent order. It's just that I want to make sure that we're kind of protected in a sense. So it's kind of like I would like to have like some sort of like language in it to where it'll kind of help us out a little bit better. To where it's like,
Well, that's actually one of the reasons that I suggested Ms. Marzorati send an email to you and copy me. One, so there's documentation of it, but two, y'all could try to work out those particulars and see if you can agree to it. And ultimately what I would do based on an outline of agreement is I would draft an order and send it back to y'all and say, this is what I think you have agreed to. Please confirm and sign off.
Yeah, because my main concern is just that I just need the security of knowing that if she doesn't vacate upon the agreed upon date, that a sheriff can just immediately act without us needing to return for another hearing, and then that, the money judgment of the $21,505.59 I'm asking for be solidified in this order. So that's kind of where my train of thought is.
So again, the money judgment is entirely different.
Yeah.
The only caveat to that is if Ms. Maserati is allowed to stay in the property for another month, there'd have to be some allowance for her to have paid to be in the property. Either she'd have to pay rent into the registry of the court,
And that
or y'all would have to agree
and that
that she has already paid pursuant to the first and last month's rent, which I know is an issue of dispute, but
yeah, because I wanted to, because we haven't had any of the money from the registry yet, I wanted to kind of ensure that the order would allow us to apply for the May registry funds like as soon as she pays it.
yes,
Like
absolutely.
we're not getting it immediately. We have to wait about a month to get these funds.
I was told that it was about 2 to 3 weeks, I think 21 days, and it is unfortunate that it takes that long. But
About a
the
month.
idea is we don't want to make it easy for people to draw funds out of the court registry because we need to take a lot of steps to make sure that it is appropriate and that that money's not being paid out incorrectly. So I'm sorry that it has delayed it, and I know how frustrating that is, but I appreciate your patience on that issue.
And I didn't object to that at all. I want them to have their money.
I am
That's,
aware of that, Ms.
yeah.
Marzorati, and I did appreciate that from the last hearing. Mr. Neal? Can you live with that approach? Which here's what I'm saying is I am telling you right now, I'm taking under advisement and I'm going to finalize a judgment that says the Mr. Neal and Miss Terry, oh, that I'm going to grant judgment in favor of Miss Marzorati in this amount of dollars, or I'm going to grant judgment in favor of Mr. Neal and Miss Terry in X amount of dollars, just like the lower court judge did. Okay. So I'm going to enter a judgment that says that might be zero, might be 21,000, any variation of those things, right? Based on the evidence that's been presented to me, the testimony I've heard from you and the materials that were submitted previously and the lease. Separately, I'm going to enter an order that says that Ms. Marzorati has to vacate the property and that you guys are entitled to a writ of possession based on her having paid rent into the property, into the registry, that you would be entitled to possession effective May the 1st, right? That's ultimately the judgment I would enter.
But also, what it yeah, I kind of I get where you're going, but it's also I just thought about something else as well. Like I wanted to see if we could have like a no stay on the appeal because if the order I would like the order to state that if she does appeal, like she must pay the double rent because she actually is in fact in holdover. So that would be $7,000 to the registry.
So those are
Especially if
issues. So the law says that she has to pay the rent that is owing in order to maintain possession of the property during the pendency of an appeal. Now, if I were to enter a writ of possession based on, my own unilateral action and order based on the evidence I've heard, which would be effective May the 1st, then you would be entitled, if Ms. Marzorati filed an appeal of the possession issue, you would be entitled to, there would be an opportunity between the parties to negotiate, not negotiate, to make motions to the court about whether she still has to pay, how much rent she still has to pay to maintain possession of the property during the pendency of the appeal. But again, the only reason I mentioned it is that one way that you might get rid of all of those issues is by agreeing, and I can't make you agree, right? My job is to give you a decision. If y'all don't agree, I will give you a decision. My suggestion simply was it might be worth your time to consider whether you could agree. And again, I'm not looking for an answer right now. That's why I suggested that Ms. Marzorati send an email that says, sure, this is what I offered to do in the property, right? During the hearing, I offered to vacate the property at the end of May. And then you could respond and say, okay, we could live with that if you would do X, Y, and Z. And then whatever y'all agree to, we would try and put it in an order that reflected that it was an agreed order. And then that would be separate from any order I enter on money judgments back and forth. And so I still think that's the way I would like for y'all to go. And then perhaps by Tuesday of next week, which gives y'all realistically 3-4 days to communicate. And if you need more time, you can tell me. But certainly by sometime next week, I would need an answer either, yes, Judge, we've reached an agreement, this is what we've agreed on, and I will reduce that to a consent order, or no, we haven't reached an agreement, we just need you to rule, and then I will rule as I have indicated, including some resolution regarding the judgment amounts, which is again separate.
Yeah,
Okay.
we're gonna need some time, to think
I
about
thought
it.
so, and I
Because,
knew I was
like,
asking a lot and giving you a lot of information at one time. Again, I do want to be clear. I'm not telling you what you must do.
right,
I do not intend to be doing that at all to either party. I'm just trying to give you suggestions for how you might work out one issue amongst yourselves that might be better for everyone. But again, my obligation is to adjudicate the case that is in front of me. And if you are not able to agree, then let me know that and I will adjudicate the case that is in front of me. Okay?
okay, because there's some things to consider because the lease agreement is supposed to end this month. Technically, if we weren't even here and she was a paying tenant and everything was fine, the lease would be ending in April, not May. So it would be considering an extra month,
Yep. No,
outside of
you
our
are
agreement.
absolutely right to be thinking about all of those things. And so that's why what I'm going to do is I'm going to ask Ms. Marzorati to send that email today when we get off the hearing. And then hopefully the parties can communicate by email, right? Because that sometimes will take a little bit of the emotion away from it because you're not trying to talk to each other and it's not as immediate as a text. Um, and see if there's some agreement that y'all can reach and let me know by Tuesday of next week. Really, there's really three things I'm looking for. Either no, we don't agree. Yes, we do agree. Or we need more time to figure out if we can come to an agreement. Those are one of the three answers I would be looking for from you by Tuesday of next week. And then I will take action appropriately from there. Okay.
Your Honor, do I CC Mr. Free
Yeah, when I
House?
said copy us, I meant
Yeah.
him. Yes,
Okay,
Mr.
good.
Freehoff. Okay.
Mhm.
Any other questions for me about how we're going to proceed from here? Miss Marzorati,
No, ma'am.
Mr. Neal, or Miss Terry? Okay. Thank you both very much. I hope you have a nice weekend and hope I will hear that y'all have been able to come to some agreement. But if not, just let me know and I will provide